A last will and testament ensures proper distribution of a person's property and assets in the event of their death in the state of Utah. Creating a will doesn't require hiring an expensive attorney in most cases. In fact, it can often be accomplished rather simply if provided the right guidance. In this video, we'll go over the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in Utah, and how and where to create an official will. Let's begin. Wills and their importance. A last will and testament, simply known as a will, is a document used to communicate in writing how an individual wishes to distribute their property among family, friends, and other beneficiaries after their death. The will maker can select the people who are to inherit all or a certain portion of their estate by naming the intended beneficiaries on the will document. Any other person or entity the maker of the will chooses can receive a cut of the estate. Now, it's worth noting what occurs upon death without a will in Utah. A person who passes away without a will loses full control of who inherits their property. The state of Utah and its succession laws instead dictates how the deceased property is handled. Assets are usually passed to the deceased spouse and/or any children, but it varies. Since clear instructions aren't left, disputes can inevitably arise between loved ones regarding who is the rightful heir to certain property, which may lead to drawn-out court trials. Therefore, it's highly recommended for all adults to have a will, especially those who are elderly or facing life-threatening conditions. Making a clear will can make all the difference when ensuring loved ones receive their fair share of the estate. And best of all, wills can be made without an expensive attorney required. A person of sound mind can draft a will in Utah with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will distribute the assets accordingly, the names of all beneficiaries, and a thorough list of the property and assets each shall receive, any additional terms and conditions, and the signatures of the testator and 2 witnesses. And finally, let's review some key legal requirements in Utah. Last will and testaments in Utah must be signed by the person to whom the will belongs, known as a testator, in the presence of 2 or more competent individuals who will act as witnesses. Though optional, it's recommended that both witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once created and signed by all parties involved, the document will be legally binding under law. Several copies can be made and given to trusted individuals for safekeeping. We're eForms, the biggest database of legal documents. We have created state-specific last will and testament templates specifically designed for Utah that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos, and visit our website for more free legal information.